This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to speak about the difference between trade dress infringement and trademark infringement, and why a clear and unambiguous exclusion is effective to avoid defending and indemnifying a person accused of trademark infringement. In State Farm Fire and Casualty versus Jason Hines, individually and doing business as Dedicated Business Systems International et al., a October 14, 2022 decision of the United States Court of Appeal for the Third Circuit that found that there was no duty to defend because of a trademark infringement exclusion. An insurance coverage dispute arose concerning the scope of two commercial liability insurance policies that were presented to the Third Circuit. The policies covered advertising injuries arising out of the infringement upon another's trade dress, but they exclude injuries arising out of trademark infringement. When the insured was sued for trademark infringement, the insurer initially agreed to defend the insured with reservations, but then the insurer moved the district court to withdraw from representation because it was solely a suit for trademark infringement, which was excluded. The insurer sued seeking a declaratory judgment, and the district court entered summary judgment in its favor. The policy's coverage of trade dress infringement claims did not extend to the suit for trademark infringement. The two commercial insurance policies at issue were issued and delivered by State Farm. In 2013, both policies used the same language in providing coverage for personal and advertising injury. That coverage included the obligation to defend against suits arising out of infringement upon another's copyright, trade dress, or slogan in your advertisement. But that advertising injury coverage excluded claims arising out of the infringement of copyright, patent, trademark, trade secret, or other intellectual property rights. Under both policies, that exclusion did not apply to infringement in an advertisement of copyright, trade dress, or slogan. Dedicated Business Systems International, DBSI, purchased those policies from State Farm for itself and its officers when conducting DBSI business. For a time, DBSI was an authorized reseller of Avaya Communications technology. The authorized reseller agreement terminated in 2013, but DBSI and one of its officers allegedly continued to access Avaya software license portals afterwards without Avaya's authorization. By doing so, they were allegedly able to distribute pirated licenses to customers for a handsome profit, all the while using Avaya's trade name and marks to falsely represent that the software was valid and authorized by Avaya. Believing that DBSI engaged in a massive illegal software piracy operation, Avaya sued DBSI and its officer. Avaya's 8-count complaint included federal claims for trademark infringement and copyright infringement. In response, State Farm sent a letter to DBSI and the officer to inform them that it had appointed counsel to defend them in the Avaya lawsuit, but that letter reserved State Farm's right to withdraw if it determined that the claims were outside the policy's scope. Consistent with its reservation of rights, State Farm initiated a lawsuit for a judgment declaring it did not have to defend or indemnify DBSI and its officer in the Avaya lawsuit. State Farm moved for summary judgment. The motion hinged on whether Avaya's complaint alleged a claim arising from trademark or copyright infringement. The district court, finding it did, entered summary judgment in favor of State Farm. Since neither policy specifically defined the two critical terms trade dress infringement and trademark infringement, the court determined that as a matter of intellectual property law, the concepts of trademark and trade dress have much in common, with trade dress often treated as a subspecies of trademark. This case did not concern trademark and trade dress in the abstract, however. It concerned insurance policies that exclude claims for trademark infringement and cover claims for trade dress infringement. First, claims for trademark infringement and trade dress infringement have distinct elements. A claim for trademark infringement has three elements. 1, a valid and legally protectable mark. 2, owned by the plaintiff. And 3, that when used by the defendant to identify goods or services is likely to create confusion concerning the origin of the goods or services. Second, a claim for trade dress infringement has different elements. It requires an articulation of the specific features of the distinct trade dress sought to be protected, followed by proof that an infringing design is non-functional, distinctive, either inherently or through secondary meaning, and likely to confuse customers. For State Farm to have a duty to defend Avaya's lawsuit against DBSI and its officer, Avaya's operative complaint must potentially state a claim for trade dress infringement. But it does not. The operative complaint never mentions trade dress, nor does it provide a basis for reasonably inferring such a claim. It does not contain the requisite description of the specific features of a trade dress that it seeks to protect. Avaya's claim lacked allegations necessary for a trade dress claim, and the district court did not err in applying New Jersey law to conclude that State Farm did not have to defend DBSI and its officer in the Avaya litigation, and therefore the judgment of the district court was affirmed. Infringing a trademark is a type of lawsuit that is often contentious and expensive to defend. Insurers like State Farm prefer to avoid such actions and exclude defense or indemnity for trademark infringement. On the other hand, trade dress infringement, putting out a product with a label that looks almost exactly like another's, is a little easier to defend and is more potential of making a profit by still avoiding or providing coverage for trade dress infringement. A trade dress infringement could simply be a wristwatch that looks like a Rolex watch but is a Bolex. Alike but not the same. A Mont Blanc pen is not the same as a Mont Blanc pen, nor is Cheerios the same as Cheeriams. The trade dress will be covered, while the trademarks of Rolex, Mont Blanc, and Cheerios will not if infringed. This video was adapted from my blog, Zalma on Insurance, which is available free to anyone who asks by simply going to zalma.com/blog. You can subscribe to the blog and you will receive it every day it is issued, usually 5 days a week. And you can also view these videos on rumble.com and youtube.com. And if you do, please click on the like button or rumble button and subscribe to the videos. You might also find interesting my locals community, and my Substack publications. Thank you for your attention.